Good afternoon. This is Greg Lois. Today we are talking about settlement and negotiations in New Jersey workers' compensation cases. And my goal today is to give a thorough overview of how we address exposure, how we're going to explain that to our clients, how we're going to discount and what our process is going to be for assessing exposure, how we document it internally, and then how we engage in successful settlement negotiations with the opposing parties. My intention was to share today our negotiation checklist. For some whatever reason, I couldn't put it into the chat, but I will email it to everyone who's attending. And the second thing to keep by your side is a copy of the statute, because New Jersey's statute describes exactly how much exposure we have in a typical New Jersey workers' compensation case with any permanent residual disability. So that's what we're going to focus on today. I'm also going to walk you through sort of our broad pattern of analysis, looking at the first step, which is a trigger, then calculating the maximum exposure, discounting the exposure, coming up with a recommendation for how we recommend to close the case and how we craft that and provide that to our client. Then receiving authority and all of the questions and issues that surround that. Then how we begin negotiations with opposing counsel, and we're going to talk about different techniques in negotiations so that we can successfully bring these cases to a close. And then what happens after we've now reached a compromise or settlement? How do we present that in court, and what are our standards for providing that information to our clients? So my goal today is to give you a really strong and thorough and comprehensive overview of this whole process. When we approach this process, our first question is always, who are the stakeholders, who's important, who's going to make these decisions, and making sure they're part of these decisions. We also want to make sure everybody's up to speed. They know what's progressing in the case, what milestones are emerging in the matter. We always want to be thoughtful about if there's a third-party case or an opportunity for reimbursement. We're going to need to know how to assess permanent residual disability, whether it's for a scheduled loss of use or a scheduled body part, or if it's under the permanent partial disability statute. Of course, we're going to have to consider Medicare considerations, and some of our clients are asking us to obtain for them general releases and resignations, and all that's pretty rare in this jurisdiction. I do want to talk about how that factors into our consideration and certainly our negotiations with the opposing party. So let's start with our triggers, and I want to go through some of the common triggers. These are not going to be every single one that's out there, just some of the most common ones that we're going to see, and I'm going to walk you through the moments when we should be reassessing exposure. We should be thinking about whether or not our exposure is increasing or decreasing, and then we're positioning ourselves for a successful settlement. So we believe that every case is following a very specific pattern, and our job as your attorneys is to help set up those cases for you so that they follow this typical pattern. So I believe the pattern is we are engaging in tactical actions to move the case forward, whether that's a motion or a discovery demand or negotiations with opposing counsel. We're doing something tactical to move the case forward. As that's developing, our job is to keep our client in the loop, make sure our client understands what's happening in the case, what are the upcoming milestones, and what direction are we going in. And I think it's just important because as the case is progressing, sometimes your exposure is increasing. There's more surgeries, there's more treatment, or sometimes it's getting better. You're developing excellent covert surveillance, which is really helping you maybe control or resolve that matter. So reporting to the client is a huge part of what our steps are in resolving matters. And as the case is developing, we're always revisiting our closure plan, our grand strategy. I think this is where the attorney and the litigation support team is helping the client in recommending next actions and keeping that case moving. We should always be pushing forward, especially in this jurisdiction. Our chief client frustrations in New Jersey is that cases move too darn slowly. Too many adjournments, too many continuances. Judges will push a case off for any reason. And so we really need to drive a case forward and be proactive. Our exposure analysis is going to inform and help us adjust those tactical actions that we're going to take in the case to move it forward with you. That's our job, is to create leverage and ultimately push a case through to case closure. So that's just how we think at LOIS. about all cases. We're doing things, we're reporting about them, and then we're revisiting that closure plan. And there should always be a closure plan in every single case that we're thinking about. So what's going to trigger off our analysis of what is our current exposure? So let's talk first about the most basic one, a receipt of an IME report from any party. When the petitioner's attorney sends us their IME report, or we receive ours, and maybe we haven't yet exchanged it with the other party, it's up to us to make sure that we analyze that IME report, make sure, did it actually address the question in this case? Oftentimes the question is only going to be, what is the nature and extent of permanent residual disability? That's the typical question. But did the doctor actually respond to that? Or did they go off on some other tangent, and do we need to adjust that? We're all going to look at the credentials and the qualifications of their experts. I generally find that we have excellent credentialed experts that we rely upon, but I find that the petitioner's attorneys are having a much more difficult time finding well-credentialed, well-established, reputable IME physicians. And I think that's the reason why they use the same IME physicians over and over and over and over and over again in every case. You keep seeing the same reports, the same doctors, because they have so few to choose from. We're also going to analyze how good is their expert on the stand, what are their qualifications, but also how well do they testify, how strong are they as a testificant. And then we're also going to consider the need to maybe get an addendum report, or to go back and get a revised report from our physician to make sure that they address the issues in the case. So that trigger is going to happen in every case at the end of the case, but sometimes as the case is developing, we're using independent medical evaluations to develop contradictory medical evidence. Another trigger, common trigger, would be, hey, we've received a settlement demand. I love receiving settlement demands from opposing counsel. Unfortunately, this is sometimes a challenge in this jurisdiction. A lot of our adversaries will say, well, I'll give you demand after we conference it with the judge. That always makes me angry, because it makes me realize, hey, what you're trying to do here is get the judge to become basically a party in the case, because once a judge has weighed in with their opinion on overall permanent residual disability, it's really tough to shake them or move them off of that opinion. So I like to begin settlement negotiations with opposing counsel outside the presence of the court, between the parties, and as soon as possible. Receipt of a settlement demand in our office triggers an immediate need for an exposure analysis in the case, and giving some recommendations immediately to our client. Another typical a trigger that would get us off on this exposure analysis is the claimant's reached maximum medical improvement, right? We know that they've reached maximum medical improvement. In most cases, I really do not need to wait for my doctor to weigh in on their independent medical examination. I'm able to kind of look at the medicals, see what the course of care was, and provide a really good estimate of exposure at that time. Another trigger is in a significant factor change in the case. And now we have an acronym here at LOIS, it's SWAMPS, for significant change in the case, which always is a triggering milestone. And it also applies here in the exposure analysis context. When the site of injury is changing, in other words, they're trying to bring in a new body part. And how many of our cases start as a left knee case, and 2 years later, now they're trying to bring in the low back or the right knee or other body parts. Their work status is changing. They've returned to work, or they've retired, or something has gone on that's changed their overall work status. When the claimant starts arguing that their average weekly wage has changed, and they're trying to argue for a higher average weekly wage, that is certainly a trigger that should have us stop and think, why are they doing that, and what is the impact going to be on our exposure? Remember, the average weekly wage is going to drive permanent residual disability exposure, so that's an important moment for us to stop and take stock of the case. When the mechanism of injury changes, the M in SWAMPS, this mechanism of injury, we put that in there because so many of our cases, the claimant says, I tripped and fell down a flight of stairs, and 2 years later, they're telling the doctor, well, actually, I slipped, fell down a flight of stairs, and then something dropped on my head. And, they start changing their story. Well, that's an important time for us to reanalyze exposure. Payment status, meaning our client is either paying or not paying, or the amount that they're paying is changing. And of course, the receipt of a settlement. So at LOIS, that's our acronym for, like, these are major case milestones that require a reevaluation of exposure. Another trigger would be client request. The client has come forward to us and said, hey, could you tell us what this case is currently evaluated at? Can you let us know? Our goal here is, when a client requests that, is to provide them with a comprehensive exposure analysis, as well as recommendations, and an action plan to begin negotiations and drive the case to settlement, and to do that within 24 hours. But sometimes in these cases, particularly where there's a lot of medical or there's been a changing medical picture, it's not possible to do that that quickly. Our practice here at LOIS is if we can't get you back a complete exposure analysis in 24 hours, we'll contact you and say, look, what you're asking for us to do is going to require a lot of research and some review. Can I give it to you Friday? Can I give it to you in 3 days? To try to renegotiate that typical 24-hour deadline. And I think that's acceptable to most clients. Another trigger is a medical status change, right? So the claim is progressing and it's 6 months into the claim, and now all of a sudden there's a request for surgery or invasive care. That's certainly going to change our exposure in the case, and that's a moment for us to sort of recenter and level set with, hey, what's the new exposure that's changing in this case? Another trigger here would be a calendar plan trigger. In other words, we like to look at reevaluate exposure every 6 months, but some of our clients say, hey, I want an evaluation every 90 days, or I want one after every proceeding. That's fine. So sometimes there will be a deadline-driven trigger. Another trigger could be, hey, there's been a legal error in this case. This comes up in the context sometimes of motions for med in temp. We've had success in the appellate division here at LOIS in challenging orders for med in temp at the appellate level. If you are contemplating filing an appeal, and it's a strategic or tactical appeal, and again, we've talked about that in prior webinars, that's a moment for us to say, wait a second, what's the value of this case? Is it going up? Is it going down? And how does this potential appeal affect that? Now, remember, sometimes you'll file a notice of appeal, or at the trial level, you can do a motion for reconsideration of a judge's order, and that will create the jeopardy that will maybe drive the case forward to some meaningful settlement discussions. So that's a wonderful trigger to be thoughtful about. The next trigger I'm going to talk about is the settlement of the third-party action, or sometimes called action over. I'm trying to get everyone to use the term action over because I think it's a better and more accurate term than third-party action. But that's where there is another jurisdictional case against somebody else, usually a civil matter, where there's the actual tortfeasor is being sued, usually by the exact same petitioner, and we have a potential for reimbursement. So when that's a potential and something's changing in that civil action, so typically it's a personal injury case sounding in civil law. It's pending in New Jersey Superior Court, and that's the constitutional court, by the way, and there's a potential for them to recover damages for pain and suffering, et cetera. That's an opportunity for reimbursement to us, and that's an opportunity for us to reevaluate our exposure, because that's going to have a huge impact in lessening our exposure. Now, I've been through a lot of triggers here, and I just wanted to give everyone a sort of a taste or a flavor of how we think about this, but this is not exhaustive. Really, any significant change in the case, the facts, the circumstances, the law, the adversary's positions, as the case develops, we should be effectively and comprehensively and consistently reevaluating exposure for you. Our goal here at LOIS is so that when the case finally is getting ready to close, we're ready to resolve it, and we ask for you for authority to move forward and make a settlement offer or conclude settlement negotiations, you're not surprised, right? That's the thing we're trying to avoid. My first job out of college, I worked for a CPA firm. I was a staff accountant. And my boss used to tell me in that job, he was an accountant, and he would say, Greg, no one fires their accountants when they get it wrong. They fire their accountants when they surprise you, right? No one likes a surprise. And that's how we need to think about exposure evaluations in our workers' compensation cases. There should be no surprises, because every time a trigger is occurring that could change the value of the case, we're letting the client know about that. We're reporting to them, and we're giving it to them in dollars and cents. We're not saying, oh, your exposure just increased. That's not enough. We need to give specifics. Okay, that's very important. So remember, tactical actions, reporting to the client, revisiting that closure plan. This is how we generally think of our case. I believe that settlement discussions is tactical, and engaging in discussions early is very important towards driving a case towards case closure. All right, so now we've looked at our triggers. Let's look at our next step. And our next step in our pattern is to start to analyze what's the actual exposure, right? Like, what is the dollar value that's going to move? And I want us to think about this sort of in order, okay? Because there are different systems that we're going to have to deploy, or different legal frameworks that we're going to deploy to consider the exposure in different types of cases. So which framework applies is sort of a basic question number one. And then it's going to be, what's the average weekly wage? Because remember, that's going to drive the dollar figure. And then we want to calculate with as best accuracy as we possibly can for our client what the likely award is going to be. And of course, we're going to consider any other payments that our client's going to have to make. And that could be, and we'll go through this, things like reimbursements to healthcare liens, et cetera, because I want to start with here's really what we think is the most accurate assessment of potentially the value that this case could cost you. Okay, so the first question, the threshold question, is what kind of case is it? What injury is it? Because that's going to drive what system or factors we're going to look at in assessing exposure. First types of case, very straightforward, scheduled loss of use type of case, hands, finger, foot, toe, eye, ear. There is a chart of disabilities. It's published in the statute, Section 12 of the Workers' Compensation Act. And that section literally says, for injuries to the arm, a maximum of X number of weeks. It's very straightforward. This is clear, easy math for us to provide to you. Of course, most of us are using the Oscar online calculator that is published by the Division of Workers' Compensation to come up with these simple, easy exposures. The challenge from the attorney perspective, or from the legal professional's perspective, is to make sure we understand what body part is involved in the case. And that's because the statute includes hand, arm, leg, foot. It doesn't say knee injury, elbow injury, wrist injury, okay? So you need to know, as a practitioner, which body parts are compensated under which system. So for example, there is no wrist listed in the workers' compensation statute. Instead, wrist injuries are compensated in terms of the statutory hand. And that's because the case law has come to define the statutory hand as everything from the elbow down to your fingertips, right? So those would all be hand injuries. And you just need to know which system to apply. So that's pretty straightforward. Also straightforward is the application of death benefits. Death benefits are payable under the statute, and there are very specific. It says 70% of average weekly wage payable to the dependent for the life of the dependent, if that's a spouse. If it's a family member who's not a spouse, for example, a child, they would get a percentage of that up until the age of 23 or graduation of college. Again, pretty straightforward, easy to calculate, but we should be calculating that with great accuracy. We calculate them here based on decennial life tables, so rated age tables, and we're using that to the best of our ability to sort of calculate what the maximum exposure is. Funeral expenses are compensable in New Jersey, not to exceed $5,000 under the statute. And again, relatively straightforward to calculate. The next system is permanent total disability. So we've talked about scheduled loss of use. We've talked about death or dependency claims. Now we're going to talk about permanent total disability, which is, again, straightforward in the statute. Someone who is permanently and totally disabled is entitled to 70% of their average weekly wage, subject to a maximum and minimum forever, for life. So again, we would calculate that out. Knowing what types of cases, though, are eligible for permanent total disability, again, is important. And I'll add in just two extra types beyond the person who can demonstrate through a medical impairment a total disability. The first is our statute, Section B, includes a section that says that the loss of specific enumerated body parts, for example, the loss of both hands, the loss of both feet, the loss of both eyes, or any two of those together, so one hand, one eye, one foot, one eye, classifies or qualifies for permanent total disability. So again, knowing some of the ins and outs of the specifics of that statute, so we know it applies. And New Jersey also has a doctrine that's found in case law called the odd lot doctrine, which says the claimant's medical impairment plus any personal debilitating factors which make them unemployable as a total industrial unit can combine together to make them totally disabled. So again, just keeping in mind the specifics of the jurisdiction to know if the claimant is qualified to have a permanent total disability award. Okay, and the last framework that we'll talk about is permanent partial disability. So this is a disability that's permanent in nature, but partial in character, meaning they are not totally disabled, or they're less than totally disabled. And again, that's compensated under the statute according to a schedule of weeks, which is a shifting schedule based on how disabled they are. And we've talked about that in prior webinars. Now, there are at least one other award that I'm aware of that someone could be entitled to under the workers' compensation law in New Jersey, and that would be for a permanent disfigurement. Unlike other jurisdictions, which might have a limit on how much permanent residual disability compensation is paid for a disfigurement, New Jersey treats a permanent facial disfigurement or disfiguring injury just like they would any other partial permanent disability. So there is no limit on how high an award could be for a facial disfigurement. However, in the context of the claimant who's returned to work, it's going to be very difficult for them to establish that their facial disfigurement is reducing their employability. And so there are defenses to those cases as well. All right, let's move on to the next step in our exposure journey, which is discounting, right? So now we've calculated what the total award could be. Now let's talk about how do we discount away from that. And I'm going to talk about 4 things very specifically. I'm going to talk about credits, apportionment, I'm going to talk about risk transfer opportunities, and I'm going to talk about how we analyze litigation risk. And in our pattern, we're now on step 3. We're going to reduce our exposure. So the first credit that I think is pretty straightforward is overpayment of temporary disability. When this has happened in your workers' compensation case, there really is no avenue under the law for you to recover an overpayment of temporary disability. So what happens is when permanent residual disability is established, when we reach permanency, at that moment, we would then argue that we're entitled to a credit for any overpayment. And this could be temp that just should never have been paid, like there was no medical evidence that they were actually disabled, or even temp that was paid while they were working by accident, or temp that was just overpaid at the wrong rate. We would recover that at the time of final settlement. The next type of exposure reduction, okay, so we're talking about discounts from exposure, is any opportunity for apportionment. Now, New Jersey's statute itself, Section 12D, says if the petitioner has any pre-existing disability to the same body part, the carrier or employer gets the benefit of a credit for that. And remember, think about that. Even if they had a disability or injury to the same body part 25 years ago, you're going to get that reduction or credit at today's dollars and reduced from your current award. So that's a really powerful statute section. And there's also case law that supports that, the cases that Abdullah. In our jurisdiction, you'll hear, practitioners say, I have an Abdullah credit of, right? And then that's because they're referring to the statute, the case law that established that right. There's also apportionment opportunities in occupational exposure cases. In an occupational exposure case, you're allowed to essentially argue that there should be liability attributed to all the prior periods of employment, all the prior carriers, and that should reduce your overall exposure. And finally, don't forget about future apportionment, okay? So this is where the claimant has had a new superseding injury, perhaps working for someone else, or maybe a non-work related accident. And this is why we think it's best practice in every case to get an updated ISO, Insurance Services Organization, Claims Index Bureau report every 6 months or so on petitioners, because they tend to be accident prone, and this might be an opportunity for us to foreclose the potential for a reopener or shift all of our exposure future into a different employer or a different carrier or into a different matter. So that's something to be thought about. Okay, then another discount is going to be risk transfer, right? So we talked earlier about what about the potential for an action over. There's a lawsuit pending against an actual tortfeasor. They're expected to recover funds from that. That's going to reduce our exposure. That's a discount to our total valuation. All right, now let's talk about litigation risk, right? And this one, sometimes clients will say to me, well, what do you think is our chances? But we want to be as accurate and specific as we can and as comprehensive as we can when we talk about litigation risk. So first thing we're going to look at is what's the strength of our case relative to the strength of the petitioner's case, and how much, which is so much of our workers' comp cases in New Jersey, it's like how well are they going to be able to establish their claims of functional loss? How well are they going to be able to show a medical impairment? Those are really the two things that the courts look at. Now, of course, the case law says under Perez that the court should also look at employability and whether or not they're working as factors. But in reality, What our jurisdiction looks at here is impairment, functional loss, and then it looks at activities of daily living. Really, wage loss or employability is not weighed as highly as those other three factors. You should also think about, as we're thinking about the strength of the relative cases, do we have any appeals pending or any opportunities to appeal? Again, appeals are pretty rare in this jurisdiction, but not motions to reconsider. So be thoughtful about whether or not you have some legal risk that you have that could help to reduce your overall exposure. Another component of litigation risk, I think, is the relative skill and negotiation history of your opponent. Knowing who your opponent is, knowing what their style is. Is this a law firm that wants a quick settlement? Is this a law firm that's scientifically driven, that has numbers that they're just trying to hit? Is this a mill that has 1,000 of these cases and has a general valuation that you know they're going to go for? Is this law firm that's representing the petitioner a tourist or a dilettante? Did they not know workers' compensation in this jurisdiction? Like, knowing all that stuff really helps you sort of figure out, okay, what are we going to do here? What do we expect? Another aspect of litigation risk is witness availability. Again, this is something where we should have an advantage because we should be able to obtain employers' witnesses relatively easy. But do we know how well someone they've testified in the past, how strong they're going to testify? What have we learned in our covert proofs about these witnesses that we're going to confront them with? Knowing how easy or how easy it is to schedule our IME doctor, how well they testify, how many times they testified for us in the past, whether or not adversary counsel has been successful in forcing them to speculate or move off of their report or create net opinions. All of that's going to go into our assessment of litigation risk. Apportionment strength, right? We talked about apportionment as a discount, but like, how good is that argument? And particularly in occupational exposure cases, how strongly do we feel that bond versus blue rose ribbon does not apply, right? So that the last employer on the risk is going to be tagged with all of the exposure. You know, the sort of analysis of that, it's going to fall down to the legal professional, but we need to do this every time we establish or evaluate exposure. How about factors personal to the claimant as considered as part of our litigation risk? What is their legal status, right? What we're seeing now with enforcement and removal orders, much more in our New York jurisdiction cases than New Jersey, but we are seeing litigants who just do not want to proceed or do not want to participate anymore in the workers' compensation proceedings. What comorbidities do they have? Or they have cancer? They have some life-threatening illness that's more important to them right now. Vocational factors, and of course, the need for money right now. Now, I'll tell you just a brief story. I try to avoid telling stories in these presentations, but I'll tell you a brief story. I had a case where my opposing counsel called me up. We were actually at trial. We were mid-trial. Calls me up and said, "Hey, Greg, I need a copy of your payment ledger." And I said, "Okay, super duper. I'm obligated to provide that to you. Can I ask why you're asking for a copy of my payment ledger? We're mid-trial. My doctor testified. We're moving on in proofs." And they said, "Oh yeah, well, my client needs to show their income history. And for the last 2 years, they've been on temporary disability benefits, Greg, and that counts as income. It's because they're trying to qualify for a mortgage. They're trying to buy a new home." Wow, that was okay. Interesting information. So I absolutely provided the payment ledger. And then I turned around to my client and said, "Hello, client. This person is looking at a major life change. They're thinking about buying a home. This is a great opportunity for us to approach settlement with this person. They need money for their down payment," right? So, knowing a little bit about the personal history or the psychosocial events that are going on in the claimant's life are going to help us position a case for settlement and perhaps discount that settlement. Another element to discount is our knowledge of the court, the venue, and the judge. This is one where you're going to want to know how involved has the judge been in settlement negotiations in the past? What have they found after trial in similar cases? I even want to know, and this is something that judges will sometimes share with us. Has the judge had the same injury as the claimant? Right? I think if the judge has had a shoulder surgery, that they're going to be a lot more amenable to awarding a high number to a claimant who had the exact same injury and maybe surgery that the judge had. And that's just normal sympathy, right? So knowing some of these things about that is important. The other part of litigation risk that, again, helps us discount these cases is what's going on in the third party. Is that third party close to settle? Is the third party a strong case? Is it a weak case? So knowing about the status of the third party case, is it coming up for a mediation? Is it coming up for a summary judgment hearing? That's the part where those parties are probably going to be close to settlement. We also have to be thoughtful because so many times in that civil context, the petitioner is using the workers' compensation case to get as much medical treatment as they can to sort of build up their third party case. So if we think, hey, the petitioner's prize or their focus is really on that civil action, all right, what can we do now in our workers' compensation case in terms of a discount to consider? What can I throw into this workers' comp case? And it might be a waiver of a lien. It might be fresh money moving. It sort of depends on the context of the case, so that they can move on and go pursue that action. And the last litigation risk factor that we analyze is, of course, covert proofs. That's where we've had surveillance done of the petitioner, or we've done social media surveys of the petitioner and discovered covert proofs that we think are going to be useful in helping us discount from our exposure. And, the most basic or most obvious example is where we have video of the petitioner and they're working full-time, full duty somewhere else, or they're clearly exceeding the limitations that their physician has placed on them. Like, those are really clear, jump off the page opportunities for us to reduce our exposure and discount. Now, it sometimes is a little challenging when you have covert proofs, because remember, when we're negotiating with another party, and we're not necessarily going to reveal that we have covert proofs, because in this jurisdiction, the petitioner testifies and then we reveal the covert proofs. So sometimes we're keeping our powder dry. We're keeping that information to ourselves. We're playing it close to the vest to lure them into testifying or lure them into making outrageous demands so that we can then drop that information after they've testified and then leverage for a better overall settlement. All right, so now we've sort of thought through our discount factors. Let's move on to the next step, okay, which is now we've got to come up with a recommendation to tell our client as to how to proceed. And there's a couple choices we have here, right? We could tell the client, hey, we think at this moment, given what the exposure is and given what the litigation risk is and our discounting, we think your best option is a trial to judgment. We think maybe we should settle the case. We could do a stipulation or an order approving settlement under Section 22. Maybe we're going to recommend a lump sum dismissal under Section 20. Or we might recommend don't do any of those things. Really, we need to do a little more investigation, or we need to create some more leverage so that we're better positioned for settlement, right? So those are going to be some of our basic recommendations. And in our pattern, we're now on to step 4, which is talking and communicating with our client, collaborating with them to make sure that we make a recommendation that's useful to the client, that's comprehensive, and that they can then act on. So one of the things we'll recommend is, hey, let's try the case to conclusion. Right now, I believe in this jurisdiction, not enough cases are tried to conclusion and not enough trials begin. Okay, maybe that is because I'm a litigating attorney. But this is a jurisdiction that hates homework, hates work. This is a court and adversarial system where they really don't want to try cases. And so you really can stick to your guns and force a trial. And by the way, no judge can order you to settle a case, okay? They do not have the power to order a Section 20 or order a settlement, okay? They can threaten all they want. But sometimes a trial is necessary, particularly where you have covert proofs that are going to be very persuasive to a judge of compensation. So when we recommend to you, hey, proceed to trial, we're going to tell you very specifically, and my goal is to tell you 1 or 2 sentences why this is your best choice. I want our attorneys to be convicted when they give you this advice, because we're going to get committed to making sure that we are going to prevail. A lot of cases, we should start the trial, but on purpose not complete them. There is no penalty to starting a trial, making or forcing the petitioner to testify, and then resuming settlement negotiations. In fact, that's a very effective strategy in this jurisdiction, particularly where you believe the petitioner's proofs are weak, the petitioner is not going to be a great testificant, or you have covert evidence. Like, those are going to be those opportunities for us to move forward. When we recommend a trial proceeding, we're always going to tell you, here's what we think it's going to cost. There's a limit to what the judge can order in terms of costs, and that limit is found in the statute, Section 64. So we should be able to predict that for you very accurately. Okay, another recommendation we might make is, hey, let's do a settlement under Section 22. That's an order approving settlement resolution. When we give you that recommendation, we're going to tell you here's what this means going forward. And of course, we're going to talk about the potential for a reopener. Reopener potential is possible. So we're going to tell you what are the risks and how can we protect you against that reopener. What I love is Section 20s. You can Section 20 all or part of a case. Often we will recommend a hybrid settlement where we will do a regular Section 22 settlement of the orthopedic and neurologic aspects of a case, and then do a Section 20 for any psychiatric claims, which are relatively easy to reopen. Our policy here at LOIS, our protocol, our best practice, is that we prefer to draft the Section 20 settlement documents. We want to draft them in a way that's favorable to you as the client and that protects us against anything down the road. We have very specific forms and templates for this, and we prefer to draft these ourselves. When we're doing a case or resolving a case under Section 20, I want you to understand what it is that we're actually buying our way out of. Because again, you can Section 20 all or just part of a case. So we do indemnity only Section 20s, we do medical only Section 20s, and then we do full and final Section 20s, which are for all parts of a case. So if we're doing an indemnity only closure, first of all, we want to confirm with you this is what we recommend and here's why. Often it's because there's a Medicare secondary payer issue. We're going to talk about the impact on pending appeals, on disputed medical bills. I'm going to make sure we reserve your Section 40 reimbursement rights. We're going to confirm with you whether or not you want a release and resignation. Again, they're pretty rare in this jurisdiction. And we're going to decide whether we're going to allow the petitioner to proceed by way of affidavit instead of appearing in court to approve that Section 20. And the reason we would allow an affidavit is really just to save time and move quickly to the final resolution of this matter. We will also at times recommend a medical only Section 20. It's pretty rare at this moment to do that, but it's possible to do a section on just the medicals. And again, we want you to be fully informed about your options there. Much more common, probably the most common Section 20 type by far, maybe 10 to 1 over other Section 20 closure types, is a full and final, which is medical and indemnity. Again, we're going to tell you what's the impact on any pending appeals, disputed medical bills. In my Section 20, we always reserve our Section 40 lien rights and state in the Section 20 that any money paid under a Section 20 is considered a payment of compensation for Section 40 reimbursement purposes. We've been successful, and actually I just did a case where by doing that in our Section 20, we got back a lot of money on the civil from a civil action. In a full and final, we're going to have to take into consideration Medicare as secondary payer, whether there's been conditional payments, or we have to do a set aside where there is a potential for future medical. Again, we're going to always anticipate and communicate with you. Do you want to do a release? Do you want a resignation? Again, exceedingly rare in this jurisdiction, but it is possible to obtain them. And then we're also going to talk about, hey, is an affidavit appropriate? Do you want the petitioner to come in and testify, or is an affidavit appropriate? I think for most full and finals, an affidavit is expeditious. It's quick. We can usually do an add-on with the judge, and we can get this case closed quickly, which is important. And the last recommendation we can make is, hey, you know what? We need to create additional leverage. You're not in your best position you could be right now in terms of exposure and discount. Let's do something to try to influence this case, try to obtain or develop some leverage towards a better settlement position for you. Generally, that's going to be let's obtain surveillance, let's do additional investigation, or let's look into prior medicals. We're going to tell you here's how long that's going to take, here's what the estimated budget is, and here's how likely that's going to help us before we make that recommendation. All right, let's move on to now seeking authority, right? So we've now made our recommendation, and we're now going to be hoping that our client is responsive to us. We're going to communicate, there's going to be some collaboration, and there's going to be some authority issued. So what I want to cover here is how we ask for it, what do we do when we get it, what do we need to know about it, like does it expire, and what are the client standards for that? So let's talk through what happens with authority. And we're now on Section 5 of sort of our pattern, our 7-step pattern. So the first thing is, Who should we ask? We want to confirm we have the right stakeholders. We want to make sure that the right people are in making the decisions as we make this next business decision, or help you make your next business decision, which is how much authority should you extend? I always think to myself, like, is there a file review coming up? And we have an opportunity to meet with the client and talk about this, right? Because we're going to be spending money. Let's have that, take that extra second to collaborate on that. Some of our clients have a high amount of desk authority, between $25,000 and $50,000 of desk authority for their claims professional or risk professional, which is great because we can move quickly in some of those smaller cases. Now, I care a lot about how our attorneys ask for authority. Okay, so we train them to be complete in their request for authority. We have a checklist and we say, go through every single step in the checklist. There's so many things that we're trying to wrap up here and trying to resolve. Make sure you spend the time to go through comprehensively every potential issue in that case before you make the ask. Be concrete in the ask, okay? And our process here is to be very specific. I do not allow the attorneys here to say, hey, give me 22% of the hand or give me 40% of partial total. Nope. They need to give it to you in dollars and cents and give an estimate of what the real money moving is going to be. And the last thing is to be committed to the ask. But I hate is when an attorney says to me, well, I'm thinking this, but maybe that. Like, no, you should really have thought all this through, communicated with opposing counsel, like reviewed the case. I want commitment here, right? Because this is an important part of our advocacy that we are doing. I believe that settlement and settlement style and moving these forward with great alacrity, like that is really an important part of what a persuasive advocate can do. So our rules here are give percentage of disability and give the exact money moving, right? Don't make someone guess at it. Don't make the risk professional do homework. Don't make the risk professional have to figure it out. Like, just tell them exactly and explain the math, right? Show your homework. This is the moment to do that. I don't like ranges of exposure. I think that's like weak and lame. But sometimes, like, even I have to give a range. I can say, well, it's going to be between this and this, but the range should be really narrow, right? I've been at this for 24 years. It's all I've ever done. And basically what we call it at, it's going to come out really close to that. And so I would say a range of about 5% is what I'll tolerate. Beyond that, you're guessing, and I don't think that you're being as committed as you need to be. So that's my number on that. And be prepared, as the advocate, to explain why that recommendation is right. And you as a client, you should demand this, right? Because if the attorney can't explain to you why they're right, how persuasive do you think they're going to be with opposing counsel and the judge if they can't tell you why they came up with their number? Our don'ts here are don't just give percentages alone. That drives me crazy. Don't give people homework assignments. That's not what we do here, right? And don't suggest wide ranges. Again, I think that's weak sauce. It's lame. Don't do it. The other thing we're going to need to confirm with our client is, does the authority expire? We have one client whose authority literally never expires. Like, they could give you authority, 2 years could roll by, and you still have that money. And then we have other clients who are saying, no, every 6 months we need to revisit that and reestablish that authority is in place. But know when it expires. If you're, received authority and 3 or 4 months have elapsed, and now the other party's saying, I'm willing to accept that offer, make sure you go back and confirm with your client that money is still there. It's still valid, right? In the Medicare entitled context, right, we're going to need to make sure that we are taking care of all conditional payments. And that has to be included in our request for authority. We should know what the conditional payments. I don't think it's enough to say, hey, we suggest a Section 20 for $50,000 plus whatever the conditional payments are, and there should be a set aside. Like, those are things that need to be fleshed out very clearly. You're asking someone to pay for something. It's not fair to say, hey, give me this amount of money plus whatever else it takes. Again, I don't think that's accurate enough. We also need to know if the client is seeking a general release or resignation. We have 2 broad buckets that our clients fall into here at LOIS: self-insured clients and insured clients. For the self-insured client, where it's all their money, when they are seeking a release or resignation, and that's the most common context that happens in, it's very simple. We will go and seek that release and resignation under the workers' compensation file. However, for our clients that are insured who want a release and resignation, I don't believe it's covered under the workers' compensation matter because you cannot purchase a policy of workers' compensation insurance that also says it will cover you doing severances or resignations of your employees, right? That's just not something that you can delegate in those policies. And so when that happens, when a insured client, the employer says, hey, Greg, we want a resignation or I want a general release, say, okay, cool. But we're not going to be able to handle it under the workers' compensation matter. And we want to be very clear about making sure we maintain those ethical boundaries. Our next step at LOIS is always going to be to document authority inside of our proprietary computer system. We document who gave it to us, what method they gave it to us, how much it was for, if it expires, all those things we document very clearly in our system. Our rules on offers are generally to follow the rules of ethics, which is that the attorney has a fiduciary duty to the client to make sure that they are shepherding and stewarding the spending of this money and making these offers and this entire process. So here, our policy is that it is always the attorney that's going to value cases. It's always the attorney that's going to seek authority from the client. It's always the attorney that's going to initiate settlement discussions with opposing counsel and make offers. However, we allow the paraprofessionals to follow up on offers that are made. And those are kind of like those tickler emails or calls like, hey, we offered you X $50,000 Section 20. Are you accepting? I think that's fine to do follow-up. Paraprofessionals here do not do settlement negotiation. They do things like finalize or draft settlement documents for the attorney's approval, but they should not be engaging in active settlement discussions, simply following up. All right, let's move on to negotiation strategy, right? Because we've now been through a lot of steps, and now we need to think about how are we going to make this offer? What tactic are we going to deploy in this negotiation? Because negotiation is an art and a skill. What else do we have to think about? Like attorney fee issues, attorney fee splits. How do we document these offers? And how often do we apprise our client of our progress and our results? So we're now in step 6 of our pattern. So the first thing I'll talk about in terms of negotiation strategy is it is our policy here at LOIS that we do not wait for maximum medical improvement in order to start soliciting settlement demands or making settlement offers. Why? The best case is a closed case. There's no reason to wait 6 months or a year until maybe someday someone's going to be done with physical therapy to start seeing if the other side wants to settle cases. Now, I have one client who said, Greg, I don't like that idea. It makes us look vulnerable and weak that we're soliciting demands. And I'm like, no, it makes you look smart that you're trying to close the case early. But again, if that's your position as a client and you say, I don't want to solicit settlement demands early, that's fine. That's your choice, and we will honor that. We'll tailor our representation. If the adversary makes a demand orally to us, we're always going to follow up in writing and document that to them. And that email is going to look like, we spoke on this day, you made a demand of so-and-so, I will be reviewing my matter and talking to my client, and I'll get back to you, something like that, to make sure that we are documenting them. When we make an offer, a written offer, I prefer always a written offer. Even if I make one orally or in phone or in court to someone, I'm always going to follow up in writing. I'm always going to say the following: here's the amount of the offer. Here's your time to respond. I like to keep it as short as possible. And then every other contingency and requirement, like you will execute Medicare secondary payer releases. You will do this. You will sign a resignation. Whatever the other contingencies are, I want to be very clear in that offer. So that's very obvious. I also believe that we should be always setting the table with opposing counsel. I do not believe on springing things on them at the end of their negotiation. So, because it drives me crazy when they do it to me. When they make a demand and they go, I'll demand is $50,000. And they go, oh, and this, and you've got to reimburse for that. Oh, and there was unauthorized medical. That drives me nuts. I get very upset with them when they start springing all these add-ons. So I try not to do that to them. If there are other issues in the case, particularly Social Security, Medicare, conditional payments, health insurance, private health insurance liens, a state temporary disability, any of these things, we should be addressing that early. Set the table so no one's acting surprised. Now, there's a lot of negotiation tactics, a lot of styles that we can deploy to make sure that we have a successful negotiation with the other side, okay? So I love when the other side makes a demand to force them to justify the demand. Say, oh, that's a cool demand. Explain it to me. Explain it to me like I'm a 7th grader who doesn't know anything about workers' comp. Explain to me. Forcing them to explain where their demand comes from is important. And so many times their demand will just be like, well, this is what I always demand in an operated cervical fusion case, Greg. And I go, okay, But why in this case? What's specific? Don't just tell me this is the rule of thumb. This is what I always get. Tell me why, right? Force them. Another tactic is to make positional offers. If you read any of the books on negotiation, I recommend the Uri books. URY is the name of the author. A lot of discussion about positioning offers, positional offers, forcing parties to put a stake in the ground, create settlement boundaries, and then work within those boundaries. That is a successful strategy for some attorneys to deploy. Other attorneys, and particularly me with my level of experience, someone will make a demand. I'll tell them, "Oh, that's your demand. Well, here's what I think the case is worth. Here's why. That's my first offer. It's my last offer. It's my best offer. Don't take it. We'll go to trial." Right? Why can I do that? Well, I have the reputation and credibility to do that. But again, I think that's a negotiation style that certain people can adopt and certain people can't. There's an option here of stair stepping, right? And one of my partners, John, he loves to stair step. You make $1 million demand, he's going to start with $400, and he's going to keep just working, and he likes that. And he does get good outcomes from those stair stepping type of offers. So knowing where the steps are, right, and making sure we collaborate with our clients so we're all on the same page is very important. Sometimes it's useful to include a third party. Now, there is no out-of-court mediation allowed by rule or law, but you could do it if you wanted to in a New Jersey workers' comp case. But oftentimes, these cases are conferenced with a judge present, okay? Just be thoughtful, though, that once your judge starts weighing in on settlement negotiations, unfortunately, you now are not negotiating against just one party. You're now negotiating against two, because judges have egos just like everyone else does. And once the judge says, "Well, Greg, I really think this is worth X, 20% of the statutory hand," it's really hard to argue and prove the judge, who always believes they're the smartest person in the room, that it's really not worth 20% of the statutory hand. So just be mindful that that can backfire. Now, it is useful, though, when the demand is outrageous, right? It's out of band, or you've got a dilettante or tourist or inexperienced attorney who doesn't know what they're doing and maybe need a judge to bring them back to reality. So those are all things that you could think about. I also sometimes have opposition counsel that'll say things to me like, "Greg, that offer is so low, I'm not even going to bring it to my client." I said to them, "Well, I just want to remind you, under the rules of professional conduct, you have a duty to bring all offers to your client. This is my offer. Please make sure it gets conveyed to your client," and press them on that, right? So that's something that you should be thoughtful about. When they just dismiss it out of hand, and this, I also see that this happens to my less experienced attorneys, who haven't been doing it for 20 plus years, and the adversary will be like, "Well, I've done this for 100 years, and well, I'm never going to tell my client about your offer." Like, nope, stick to your gun. Say, that's the offer. You need to tell them about it. You don't know what their situation is. I think it is best practice, and something we do here, to always make the offer time dependent. And that there's some flexibility to that. Usually I say you have a week to respond, you have 2 weeks to respond, or you have until the next listing to respond, right? But I want there to be sort of a boundary on how long this is going to take. I do not believe anymore when someone says, "I can't get a hold of my client." I think, okay, your client has fled the country or whatever, or is incarcerated or something. Cool. Now you've told me something useful. I can have more leverage, right? When it takes them weeks and weeks to respond to an offer, something's desperately wrong with their case, and you should be pressing forward. That would actually, to me, be something that would get me thinking motion to dismiss for lack of prosecution. And the other thing that you can do is create false dependencies to drive urgency. What do I mean by that, Greg? Are you telling me to do something false? Yeah, sort of. But sometimes I'll tell my adversaries, like, "Hey," because this happens all the time, right? I have a file review coming up in a month, and I'll say, "Hey, I got a file review next month. Why don't you give me your demand? Because I know by then I'll have money, and we can start talking turkey on this case." But sometimes you tell them, like, "Look, I'm going on vacation, and I'd like to get this case settled now. Can you give me," come up with an anchor, a plausible anchor as to why the other party should respond to you now. Create that urgency, okay? Another thing to be thinking about as you negotiate the closure of your case is, how's everybody getting paid? The petitioner's attorney gets paid generally 25% of any award that's moving. But in some contexts, they don't, particularly where you're doing a waiver of reimbursement, perhaps, as the consideration for a Section 20, because there's a third-party action. So just be thoughtful about clever ways that you can craft these settlements. Make sure the attorney gets something out of it so that they're there advocating with their client that they are going to try to settle this case. Generally speaking, you want to be thoughtful about that, particularly where there's successive attorneys and they are maybe fighting or challenging whether or not what kind of fee they're entitled to. That's an important opportunity for us. Now, as these settlement discussions are progressing, our rule here is document, document, document. I want my attorneys to go on vacation. I want them to have their sick days and whatever. Everybody else in the file, in the office, needs to be able to pick up this file. Now, we are 52 attorneys. We're defending over 4,000 cases on any given day. But every attorney has to handle and document their case in such a way that any other person, any paraprofessional in this entire office, would pick it up and be able to run with it and continue those settlement negotiations. That's important for continuity for our clients. So that's something that we really harp on. And of course, we're trying to keep the client as best informed as we can. It doesn't mean every back and forth we're going to repeat to them, but every milestone, every time the ball is moving down the field towards that eventual settlement, client needs to be in the loop. They need to know what's happening. Last step is, what are our protocols for putting cases through on the record and then transmitting that information to our clients? So, our protocol here is generally to allow affidavit settlements versus in-person testimony, and to seek add-ons, meaning calling up a judge and saying, Judge, we just settled this case. Can we add this onto your calendar tomorrow? And most judges in New Jersey will allow you to do that. So once you reach a settlement, actually getting that put through on the record should be just a few days at most. Our best practice here is that the defense should draft the documents. That way we're not waiting on the other party to do it. And then we're to circulate them quickly. One of the biggest barriers here is, after we've given the settlement documents to opposing counsel, waiting 2 weeks, 3 weeks, a month for them to bring their client into the office and actually sign these things. So we're now on our last step, which is, what do we do with settlement documents? Again, our pattern here is to request add-on settlement approval proceedings, and that's being able to just call up the judge and say, Your Honor, can we please add this on tomorrow? All the parties are ready to go. I also authorize here the use of affidavits to settle matters. This started during COVID, really way more, and now it's like every case, everybody wants to do an affidavit. I'm comfortable with doing affidavit settlements, but only if the affidavit is complete. It needs to completely document the person's current activities of daily living and limitations, and that helps protect us against the potential for a reopener. Again, drafting our settlement documents ourselves, not waiting for the other side to do that, with a one-day turnaround time, is going to get these cases to settle faster. Once we do reach settlement, our goal is to make sure that our client has the settlement documents and specific instructions on how to pay everything that needs to be paid out under the settlement within 24 hours. You have 60 days under the statute to make a payment of compensation following a settlement or a judicial order. However, there's no reason to delay, so we want to get that information to you as quickly as we can. All right, let's turn this over for questions. I know I went a little bit over on time, or we're just about a minute under on time, but let me take a look here and just see if there's any questions. And I'll leave it on this slide as I do that. So, don't see any questions in the Q&A. Let me open up the chat and see if there's anything in there. I don't see any questions. All right, that's good. I guess when I said this was going to be a comprehensive overview of exposure and settlement, it really was.